Welcome, everyone. AbilityFirst and Lagerlof are pleased to partner together to offer this estate planning webinar, and we're very excited to have you join us this afternoon. We had a wonderful response with many RSVPs and are looking forward to learning alongside all of you. Before we begin, I would like to note that Spanish interpretation is available for today's session. I'll now invite our interpreter, Mark, to share instructions on how to access language interpretation. He will provide instructions in both English and Spanish, after which we will get started. Mark, please go ahead.
Thank you so much, Lana. We'll go ahead and do that now. We'll get started with instructions in Spanish first for the benefit of our Spanish-speaking audience. Muy buenas tardes. Queremos dejarles saber que se ofrecen servicios de interpretación para la sesión de hoy. Para escuchar el programa en español, seleccione, por favor, el icono de un globo terráqueo que aparece en la parte inferior de su pantalla que dice Interpretation o interpretación. Luego seleccione su idioma Spanish o español y de ahí podrá escuchar el programa enteramente en su idioma. Asimismo, tengan en cuenta que se ha habilitado la función de chat y les invitamos a utilizarla para escribir sus preguntas, las cuales serán leídas en voz alta durante la sesión. So please note, we do have interpretation services being offered for today's session. To listen to any comments or questions that are made in Spanish, please select the globe icon at the bottom of your screen that says interpretation, and then select your language, English, and you'll then be able to hear a live rendering of that comment into English. Also, please note the chat function has been enabled, and you're welcome to use it to type in your questions to be read aloud during the Q&A portion of the program. Thank you, Lana. Back to you.
Thank you, Mark. The Spanish channel is available, so anyone who would like interpretation can join the channel. As a quick reminder, please mute your microphones to minimize background noise. I would also like to note that we will have time for questions and answers at the end, so please be sure to put any questions in the chat and we'll be happy to address them then.
I did.
Okay. Before I hand it over to our presenter, I would like to introduce myself. My name is Lana Masarian, and I'm the Director of Development at AbilityFirst. We're honored to be one of Lagerlof's charitable partners. We're a nonprofit organization serving children and adults with developmental and intellectual disabilities, and we're proudly celebrating our centennial this year. For 100 years, AbilityFirst supported individuals with disabilities in achieving their personal goals, building confidence, and fostering a sense of belonging. AbilityFirst is headquartered in Pasadena, with centers in Long Beach, Inglewood, East Los Angeles, Pasadena, Claremont, and Crestline. Our programs include after-school enrichment, employment services, college-to-career pathways, community integration, aquatics, and summer camp. We will share our website and contact information at the end of the presentation, and I would be happy to connect with anyone interested in learning more about AbilityFirst and our programs. Now it's my pleasure to introduce our presenter, Josh Driscoll, Managing Partner at Lagerlof and Chair of the Private Client Services Department. Josh specializes in estate planning, wealth transfer, business succession planning. He also advises clients on charitable giving and has helped establish numerous charitable trusts and private foundations. In addition to his legal work, Josh is actively involved in the community and serves on several nonprofit boards in the Pasadena area. We're grateful to have him join us today. Josh, thank you for sharing your expertise on estate planning and the role of charitable giving. Please take it away.
Absolutely. Thank you so much. And it's a pleasure to be here with everybody. This is the second time that we've done this series. So hopefully we've got some repeat people that are joining us, or if you're new to this, there are no silly questions. So please make sure that you ask those either throughout the program, and we'll congregate them towards the end in the Q&A session, or if I happen to notice it and it's relevant to the topic, I'll try to address it while we're doing that. So just to kind of the housekeeping items here, some of the things that we're going to go over, just to give everybody sort of the same level footing as to what we're going to talk about. So some estate planning basics. So what typically makes up an estate plan? What documents are you going to want to make sure that in the event something happens, your estate is handled, or that there are others that are able to act on your behalf if something bad were to happen. So furthering into that, the essential estate planning documents and what they are, how they work together, what you might have to compare to your own estate plan, or if there are questions about the types of documents that you should have. We'll get into that. Beneficiaries and charitable giving. So, who are your beneficiaries? How can you weave in charitable intent to your estate plan? When is it a good idea to do that? When maybe should you look at other alternatives to estate plan charitable giving, talking about donor advised funds, other things like that. We'll talk about understanding different types of bequests. So bequest is like a gift. So different types of ways that you can leave assets to others through your estate plan. So we'll talk about that. And then we'll kind of round it out with charitable planning opportunities, how you're able to use your charitable intent and do that through your estate planning documents or other methods. So pretty full agenda, but we'll try to make it manageable for everybody. There's a lot here. So again, there's no silly questions. If you have a question about something, just put it in the chat and we'll try to acknowledge. All right, next slide, please. All right, so is that the next one? I've got estate planning basics, but I'll go with this. There we go. All right, thank you. So estate planning basics, right? So these are some of the core key terms and things you should be thinking about when you start to have that conversation, either with your attorney or if you start to think about things as it relates to your estate plan. These are some of the buzzwords that are going to come up, and these are the things to think about. So what is estate planning, right? It means different things to different people. Some people think, well, I've done my estate plan, I've written a will, or I've written down what I want to have happen on a piece of notebook paper. My kids know where it is, and they're going to follow that in the event something happens to me. But estate planning at its core really is organizing and managing your assets and financial affairs to make sure that at the end of the day, when you pass away, that they're distributed according to your wishes, right? And we generally add on to that, trying to minimize tax wherever possible and legal complications, right? Probably the easiest way to plan your estate is to write it on a piece of notebook paper, sign it, and put it in a drawer and tell your kids where it is. That's pretty easy to do, right? You could do it right now while we're doing the webinar, but it's full of legal complications in the event something happens, right? It's probably not the most efficient way, big picture, to plan your estate. Kind of on the other end of that is a very complex trust structure where it has multiple trustees and multiple trusts. And there's always kind of a happy medium. Working with an estate planner, somebody that you trust to help advise you on the best structure is going to be super important to make sure you get the best overall plan for you and for your family. So some key terms we'll talk about and that will come up periodically. Estate tax. So yes, there is an estate tax in the United States. In California, it's probably one of the only taxes that we don't have. We used to have an estate tax in California, but it's been long eliminated. So you don't have to necessarily worry about a California estate tax, but there is a federal estate tax. Right now, the federal estate tax exemption, meaning the amount of money that you can have and pass to your heirs, is $15 million per person. That's a significant number. So what that really means in practical terms is you can have $15 million worth of assets and you can pass away and none of that is taxed. It goes to your kids or to your grandkids or to whomever it is you're leaving it to, free of tax. Once you go above that $15 million exemption amount, so you have $16 million, for example, that $1 million difference, the difference between the exemption and the amount of assets that you have, is going to be taxed. And it's taxed pretty heftily. It's taxed at 40%. So every dollar over that $15 million or $30 million if you're married is taxed at 40%. There are some ways to handle that. Start saving. Just kidding. But there are some ways to deal with it, right? That we handle estate tax in a number of ways. Sometimes life insurance through irrevocable life insurance trusts. Sometimes giving assets away during your life to your kids or to others so that you can take advantage of discounts that may be possible when you do gifting during life based on how you structure that gift. So definitely more than the scope of this presentation, but something to kind of keep in mind. and start to think about, where you're at right now, because it's not just that, oh, well, we're at $15 million right now or $14 million. We should be fine. You really are looking at, are your assets going to increase in value faster than the increase in the estate tax exemption? Roughly, the estate tax exemption goes up somewhere between $600,000 and $900,000 per year when it's indexed for inflation. So just kind of something to keep in mind. Sometimes assets go up significantly more than that. So just something to kind of bear in mind while you're thinking about that. I feel the same way about estate tax sometimes. Executor, what's an executor, right? An executor is the person who's going to take your estate and manage it after your death. Executors serve under a will. So you have your trust, you have a trustee. Your will is managed by your executor, the person that you nominate to deal with your estate after your death. That person will serve pursuant to your will and must be appointed formally by a court. Ideally, if we're doing everything right, you don't necessarily have a probate estate to open, and you don't necessarily have to have an executor that will be acting, but you do nominate someone. Wills are really a backup in the trust scenario. You don't want to rely on them. You want to really rely on the trust. Beneficiaries, that's the person who's going to inherit your assets after death. So the person who will get everything if you pass away. Probate or intestate succession, they're really two different things. Probate is a court supervised process where your assets are distributed. So think about this. You have a will, you pass away, your assets must be probated, if you've heard that term, meaning that the court must accept your will and say, yep, this is what Mary wanted. This is her will. We can validate her signature. We can see that the executor is here. He has the original will, or she has the original will. We're going to admit this will to probate, and we're going to allow for the executor to marshal the assets, meaning gather all of the person's assets and distribute them according to the will after they have paid their taxes, paid any expenses of their last illness, paid any debts that they have, so on and so forth. That's the probate process. Intestate succession is what happens if you don't have a will. You still go through probate if you don't have a will, but you follow a code section referred to as intestate succession that lays out who gets what in that scenario. So the state does have a list, not of names, but of positions in your life of who will get things if you pass away and don't have a will. Trust and trustee. So a trust is very similar to a will, but if for those of you that have both a will and a trust, your will is probably 5 or 6 pages and your trust is probably 60 pages. Well, what's the difference if they're both doing the same thing? Well, a will is very simple and just basically says, I'm of sound mind and body. I want my assets to be distributed to the following people at my death. 1, 2, 3. A trust goes beyond that. A trust is more like a contract, and the contract specifically outlines the terms and the ways in which people are going to get things. You can say, well, my kids aren't going to get it until they're 50 years old, or my kids will never get it. It's going to bypass them and go to my grandkids, or it's going to go here or go there. So you can do that much more easily in a trust than you can in a will. And the trust does not have to be probated, go through the court process, whereas a will must go through the court process in order to be valid. So what's the importance of planning? Well, some people take the idea of like, well, I'm gone, I'm going to be deceased, why do I care what happens to it? Well, or I think the following is going to happen, it's going to go to my spouse, or it's going to go to my kids. And generally that's true, but not always. There are fact scenarios where that intestate succession situation that I mentioned earlier, where the state has a law that basically says how assets are distributed upon death, will sometimes be different than what somebody expects, particularly in second marriage scenarios, particularly where there are several children. Assets are not just automatically distributed to the surviving spouse. They sometimes can be broken up and distributed to other parties. That often surprises people. So making sure that your assets are distributed according to how you want them, not how the state thinks that you should want them. Minimizing taxes and legal fees. If you've looked into estate planning, you know that a will is cheaper to produce than a trust, but a will is much more expensive long term than a trust to administer, just based on the way that the court costs are and things like that. You're going to get it one way or another. Either at the beginning when you create the plan, it's going to cost a little bit more if you go for a trust route than a will, but ultimately it's going to be cheaper to administer, generally speaking, over the long haul. And you can provide for family and charitable interests. You can do that through a will as well, but it's not quite as robust or easy. So definitely, it's important to think about planning, important to give it some time, give it some thought, and not just rush into it or download a form online and think that that's going to solve sort of what you're looking for. You really want to start thinking about the implications of the gifts that you're making. Supporting charitable goals. So estate plans, whether you're using a will or a trust, can be structured to include charitable giving. So if you're so charitably inclined, very easy to include that within a plan. And there are ways to do that at death. There's ways to do it during life. We'll talk about some of that. And it really comes down to what's important to you, right? If you really, like a nonprofit or a charity, and you want to see that the money that you're giving them go to good use while you're alive, that could lead you down one path of planning. Or if you say, well, whatever's left at the end of the day, I want it to all go to the XYZ Society, that's a valid thing as well. And your charitable goals can align with your philanthropic objectives and maximize impact. That's really getting more into the creation of a foundation or putting in place some type of charitable structure that will last over a period of time to really benefit a nonprofit more long term. You have a couple ways of giving money to nonprofits. You can give it to them outright and say, here you go. I hope, here's the $1 million. I hope it all goes well. Great. Or you can say, I'm going to make you a beneficiary of this trust. We're going to distribute X dollars per year to you, or some kind of foundation. Both have their place. All right, next slide, please. All right, the estate planning process. So this is for those of you that have done it, this will seem somewhat familiar. For those of you that haven't, this is sort of a sneak peek for what it's going to look like to do some estate planning. And this also sort of applies to an old plan. So if you've went to an attorney many moons ago and you created a plan and you sort of put it in a closet or a drawer and you said, okay, it's over there, I did it, check. This sort of applies to you as well. Those plans, whether you did it a long time ago or don't have one, they really need to be reviewed every so often. We'll talk about the recommendation there. You can see it's generally 3 years, but we'll talk about when that should be a little bit sooner or when you can go a little bit longer. So what does it look like? Well, any good estate planner or any good estate planning process is going to start with some type of initial assessment, right? When I talk to clients, and I do this all day, talking about their assets, talking about what's important to them, we're really looking at, evaluating assets and liabilities. Assets are, what do you own, right? What things do you have that you own and control? Well, we have this house, we have oil rights, we have, a vacation property, we have X, Y, and Z, an insurance plan, whatever the case may be, right? Looking at the assets and trying to get an idea of, what those look like, both from a value perspective, but also from an administrative perspective. How easy is this going to be to administer? The classic thing that comes up when we see this from time to time are things like timeshares, right? They always seem like a great idea when you're there and you've had a Mai Tai or something and they've given you a free steak dinner and you're like, I want a timeshare. Well, they're a nightmare, right? Both probably during your life, but also at death, right? Depending upon where they are. I've probably dealt with a timeshare in just about every state at this point. They're very different depending upon where they are as to how they're transferred. So those are examples, when I see a timeshare, I'll bring it up and I'll say, well, what's the plan for the timeshare? Oh, my daughter wants it, or nobody wants it. That helps us start to try to plan and think about the easiest way to deal with that asset. And that's just an example, one of many, right? So we'll talk about your assets, but we'll also talk about your liabilities. Who do you owe money to or what liabilities exist? Mortgages are relatively straightforward, right? They're generally secured by the property, things like that. But there are other types of liabilities. maybe tax debt that's out there, maybe some type of investment in which you have a potential capital call that could happen, things like that. So we'll sort of talk about your desires as it relates to those things and really get into your personal and charitable goals. What's the intent of the plan? Is it really just to make sure that things are clean, neat, and orderly if you pass away? Okay, that's relatively straightforward. Or is it more complex, right? Your plan is to not create a situation in which a child or a beneficiary is somehow triggered by an amount of money that comes to them and within their control. Think about folks that maybe have issues with drugs or alcohol, things like that. We're oftentimes talking about how do we create something that benefits them, but doesn't create a situation in which they're triggered or they're otherwise enabled to go out and continue behavior that we don't want, right? So that comes up very frequently, and it's something that you should feel comfortable talking to your professionals about because they can help you kind of guide the best way to deal with that. And charitable goals. What charities are important to you? And it's not, I go a little step further. It's not just what charity is important to you, but what's important to you about what they're doing, right? Because when you're giving money to a charity, it can either be an unrestricted gift. Here's $1 million. Go have fun with it. Go do something. Or it can be a very specific type of bequest where you're saying, I want you to do X with my dollars, or I want to put this in the XYZ fund to build a new building or to start a new program or to, endow some scholarship fund or something. So talking about charitable goals and making sure that those are aligned with what you're looking to do is very important. Working with professionals. Can't stress this part enough. I've certainly seen plenty of situations where someone, either people don't really do this anymore. They don't go to Staples and buy a form. They just download it on Google or something. But it's sort of the same equivalent, right? You go and it's kind of worse, actually. I probably prefer the Staples form over the Google Trust these days. But the hard part about doing something like that or finding your documents or relying upon an old form is it looks right because you don't know what you're reading. And it looks like, oh, okay. It's sort of like reading a recipe for something you've never made. Okay, well, 10 cups of sugar. That sounds fantastic. I bet it's going to be tasty, right? Well, and then you eat it and it tastes like crap. Well, it's sort of the same thing, right? When you just pull a form offline, you don't really know what you're looking for. So collaborating with an attorney, financial advisor, tax professional, those are really the key components to an estate plan because all three of those folks are going to be needed. An attorney, certainly from the legal side, right? What legally can you do? How do we put in place this trust? How do we, facilitate your goals and desires based on what you've told me? Financial planner's role really is to look at the money and to say, okay, here's where we're going to invest X, Y, and Z to make sure that there's money to do what you've said. And then the tax advisor to make sure that, from a tax perspective, you're not triggering something or doing something that could otherwise, generate some type of tax. We're certainly conversant in all of those things, and we'll talk about all of those when we meet. And definitely on the tax side, that's something that we get heavily involved in. But that team is really important. And that team also helps to ensure that there's something comprehensive and it's legally sound, right? Every time that we meet with somebody like this, we do a group meeting where there's a CPA and the tax professional and financial planner involved. That plan comes out better than if we had just done it alone. And the reason for that is everybody has their slant or thing that they look at when it comes to the plan. And oftentimes those folks that you're dealing with, they all know just a little bit about something in your life that the other professional does not know, right? They may remember that 10 years ago, your child had an issue with X, Y, and Z, and they'll remember to bring that up, or that you had a problem with something or whatnot. So it's good to involve those folks. You'll have a better plan ultimately. And then what's the recommendation for reviewing and updating it? Generally speaking, the best practice is about every 3 years that you should look at it. Doesn't mean that it needs updated every 3 years. It just means that you should have it reviewed and have a brief conversation with your counsel, your attorney about it, and say, does this plan still work for me? So we have a process here where we reach out to clients and say, okay, it's been 3 years. It's time. We should talk about your plan and make sure everything's fine. What we look at there is almost like a, 100-point inspection when you take your car in, right? You're not necessarily coming in saying the brakes are squealing and this is wrong and that is wrong. You're saying, okay, is anything going on here? And what we look at is, are your trustees still good? Do these people still make sense? If something happens to you, does it still make sense that this person that you've listed here takes over? Most of the time, yes, but sometimes people move away, friendships change, people pass away, they're incapacitated, whatever. It's good to, kind of keep up on that and make sure that that's right. We also look at your beneficiary list. Is anybody left out? Do you want to change anything? Do you still want to give it all to X, Y, and Z? Those types of things. And then we look certainly for laws and financial changes, right? The biggest would be, you're starting to creep up towards that exemption that we talked about at the beginning of the webinar, $15 million. I keep track of that. And, the closer we get to that, the more we start talking about, do we need to do any kind of advanced planning? So if you're keeping up on it about every 3 years, that's a good, kind of a good cadence to work from. What might cause you to go earlier? Well, certainly if you know that your trustees are not appropriate, right? The person who's listed in your documents passes away or moves out of the country or something like that. I wouldn't wait the full 3 years. I would go ahead and reach out and have it changed sooner than that, right? And of course, it often doesn't mean just changing the trust. It means changing all of the documents because generally speaking, the best practice is to list the same person throughout all of the documents for ease of administration if something happens. So definitely, if you're aware that your trustee is no longer good, or if you have another child or a grandchild and you've specifically listed, with names, distribution amounts, things like that, you'll want to reach out to your attorney and change it. Or if you hear about changes to the law that you think may apply to you, I wouldn't wait for your attorney to reach out. They may be inundated with changes. Reach out proactively and say, hey, does this apply to me? Is this something that we want to think about? Those types of things. So those are kind of the big things. But again, about every 3 years, sometimes a little bit sooner. If literally nothing has changed in your life and you could just as easily be, 3 years in the past or 5 years in the past as you are today, then maybe you can push it just a little bit. But it doesn't hurt to have it checked out about every 3 years. All right, next slide. All right, so now we're going to talk more specifics on the documents, right? We talked about these a little bit, so we don't have to spend a ton of time here. But a will, right? Will is a legal document. It's the thing that most people are most familiar with when it comes to estate planning. It's, the estate planning document. It's been used forever and ever and ever, and it continues to have its place. A will is a legal document specifically listing asset distribution, generally care of minor children. So who's going to be the guardian if something should happen. That can sometimes be in a separate document, but oftentimes in a will. Appointment of an executor, right? Who that person is. And when you have a trust, you're oftentimes going to see a will that's referred to as a pour over will. It's pouring assets over into the trust, but the will still has its place. There could be a wrongful death action that's being brought by the administrator. There could be, a situation where there's a lawsuit about a contract claim. You're building a house, you're doing something like that, and you need to have somebody bring that lawsuit. That would be the administrator or the executor, things like that. Trusts, again, we spent some time here. Revocable versus irrevocable. Revocable trust is exactly that. It can be changed, modified, very flexible. You can, do pretty much anything to the trust during your life. If you're married, you tend to have, right? If you're married and both parties have created the trust, if one party passes away, a portion of the trust typically remains revocable, able to be changed, and then a portion of the trust becomes irrevocable, not able to be changed. Irrevocable trusts are exactly that, right? Once you've made an irrevocable trust, it is a completed gift. It is a permanent gift to someone, or a permanent distribution, however you've structured it. Oftentimes, irrevocable trusts are done for kind of two reasons. Asset protection, meaning I don't want this in my name. I don't want somebody to be able to recover from me if there's some type of problem or accident, or tax benefits, kind of harkening back to what we talked about earlier, distributing assets out, getting them out of your state while you can get a discount. Power of attorney and healthcare directives. So powers of attorney are the documents that designate other individuals to make decisions on your behalf. A durable financial power of attorney is the document that would allow someone to make a financial decision on your behalf. A healthcare directive or a healthcare power of attorney is the equivalent on the medical side. This is where you're alive, but you may not be able to make decisions for yourself. So the powers of attorney come in two flavors, either immediately effective or springing. An immediately effective power of attorney is exactly that. I'm alive, I'm competent, I can make my own decisions, but I need someone to be able to act on my behalf. That's an immediately effective power of attorney. I'm going to be out of the country, or I travel frequently, whatever. I want a power of attorney to do something for me. That's an immediately effective power of attorney. The alternative to that is a healthcare power, or a springing power of attorney, which it springs to life in the event you're incapacitated. You can't make medical decisions. You can't make financial decisions. You have some kind of incapacity. One or two doctors, depending on the document, say, Josh can't make these decisions. He's incapable of doing that at this time. The springing power of attorney takes effect. If I ultimately regain my capacity, maybe it was temporary, I was in a coma, I had some type of medical episode, whatever, then that power of attorney goes ineffective again for that period of time, and I'm back to making my own decisions. I would say it's 50-50 of what I see of clients doing immediately effective or springing. It's really a preference, and we'll talk about the preference and why you might do one over another. Advanced directives and living wills. This is the document that says, hey, if I'm in a coma and I'm in a vegetative state for a long period of time, I want you to pull the plug, kind of thing, right? So that's an advanced directive or a living will. We'll talk about that. Your plan should, your power of attorney, the healthcare power of attorney should address this, or there should be another separate document that addresses this. And it will tell you, what powers the agent has in this regard. The vast majority of people generally select, yes, the agent has power to withdraw life support, has power to, pull the plug, so to speak. Doesn't mean they're going to. Doesn't even mean that the hospital will let them do that because of your medical situation at the time, but it does give them the authority to do that. This is often confused with a DNR, or do not resuscitate order. And sometimes clients will say, I have a DNR. And 99 times out of 100, what they're referring to is a living will or an advanced directive. We don't produce, and no estate planner that I'm aware of produces do not resuscitate orders. Those are specific to the facility that you're in, right? So if you think about it that way, you check into Huntington Hospital for a procedure, or you're there based on something, and you say, I have a DNR. If I pass away while I'm here, I have a heart attack or something, I don't want you to resuscitate me. That is specific to the institution, generally speaking, and not something that's in your estate planning documents. Next slide, please. All right. So now getting into kind of beneficiaries and charitable giving. So what's the role of a beneficiary? Well, every plan has to have a beneficiary. It's got to go somewhere, right? So assets have to be distributed somehow. And that's your beneficiary. So the beneficiaries are going to be the party that receives assets from the estate based on the terms of the trust, based on the terms of the will. Most common beneficiaries, right, are going to be family members, your kids, your grandkids, your nieces and nephews, your siblings, parents sometimes, whatever. Those are your most common beneficiaries. Then you get into friends, right? People that have meant something to you during your life. Sometimes folks will leave trusted employees money in their plans. Sometimes they'll leave caregivers money in their plans. things like that. That's one that you need to kind of look out for if that's your intent, is to do a caregiver gift. There's some additional things we want to do to document a gift like that, but perfectly acceptable if that's what you want to do and you have capacity. Then you have charitable organizations, right? Groups like AbilityFirst and others that you might want to benefit at the time of your death or potentially during your life, depending on the types of gifts that you're going to give. And then institutions, right? Think about USC or UCLA or things like that, right? Typical choices are your alma mater or schools or facilities in which you worked for many years, things like that. We see that oftentimes. Best practice for yourself and for us when we're planning this is to reach out to the organization that we're going to be nominating or giving a gift and asking them if there are any specific guidelines, not guidelines for the gift per se, but how they need to be named in the documents, right? So it's oftentimes we represent a number of nonprofits locally that receive charitable gifts regularly. And I have seen many variations of the names of these institutions or organizations. You would think that, everybody thinks of it as, I'll just use Huntington Gardens, right? Oh, Huntington Gardens, they leave it to that. But that's not necessarily the actual legal name for the Huntington Gardens, right? And there might be other Huntington Gardens throughout the US. There's some confusion, right? Your trustee says, well, I think they mean the one in Pasadena. They lived across the street from it and went there every day of their life. I assume that's what they mean. But somebody in the plan is saying, well, it could be the Huntington Gardens that's in, Walnut Creek. And so there's some confusion there. You want to make sure you're listing it as direct and clear as possible, particularly with charitable organizations and others. And you're designating those beneficiaries in the plans, right? Doing a specific designation ensures that those assets pass according to your personal wishes rather than state intestacy rules, which we talked about, right? If you have nothing, right, you've created no plan, you've not written down anything, you just essentially passed away unexpectedly, many people say, oh, your assets are going to go to the state. That's not really true 99% of the time. It does happen, but the only time it happens is if no living beneficiary or living heir under the intestacy rules can be found. And that sometimes happens, particularly with folks that are from small families or they're estranged from their families. There can be, that can happen, right? Because there just isn't somebody. We don't know enough. There was no materials left. We can't find anything. And in those cases, we'll engage an heir search company. We'll try to find someone to be able to, tell us, where does this go? But very, very, very infrequently, the answer is we don't know, can't find anyone. And the court will say, okay, we'll send it to the state of California. And if somebody finds it within a period of time that's allowed, then they can claim it. And otherwise, it goes to the state's general fund to be used, I'm sure, very, very well. So important that you have something, right? Designating charitable beneficiaries. Again, we talked about that. Include charities as beneficiaries in the will, trusts. You can do it with retirement accounts, with life insurance policies. Obviously, the will and the trust can only control what it contains. Retirement accounts are generally not owned by the trust. They remain in your individual names. So if you're going to leave your, an asset retirement part of your retirement account to a nonprofit, you'll want to reach out to them and make sure that they're able to accept that and how they should be named. Same thing with life insurance policy. Strategies for gifting through estates, right? So there's a couple different ways that you can do this. You can do direct gifts, or you can do it through some type of charitable trust. Direct gifts are the simplest. You specify a fixed dollar amount or a percentage or a specific asset. So think about real estate, securities, artworks to the charity, right? You say, we'll stick with our Huntington example, right? People oftentimes think of the Huntington Gardens as, Pasadena's basement, and they say, well, I think you probably want this old piece of art that I have. 99 times out of 100, Huntington doesn't want it, and they'll tell you that. But sometimes they do. And there's specific things that they'll take. I've been involved in many estates where they'll be left the entire personal property contents. 100 paintings and they'll want two, right? The rest of them, they'll politely decline and say, no, we don't have room in our collections, or our archivists don't think that it meets the standards of the Huntington or whatnot. And they'll politely decline that. Doesn't mean they don't want your gift and they don't need your dollars in order to, continue to operate. But no one was really thinking. I mean, the attorney just said, "Oh, all the artwork to the Huntington, let them figure it out." Well, the person would probably have done something different with the rest of that artwork if they had known what the Huntington. And I'm not picking on the Huntington. Huntington's great, and all institutions do exactly what I just described. They would have said, "Okay, well, let's talk to the Huntington ahead of time. Let's have them come out and take a look and see what it is that they have." And they may designate specific artwork that they have. And that actually allows them to do a much better job of accepting the gift, and a much better job overall of acknowledging you as a benefactor to them. Real estate is the same, right? People will leave real estate to a nonprofit. Most of the time, the nonprofit immediately sells it. Same thing with securities. The exception to that would be if it's connected to the school in some way, right? A piece of property directly across the street from Caltech. They're unlikely to sell that. They're likely to keep it and do something with it, put it in their master plan, something like that. But if you leave them a piece of property, some vacant farmland in Kern County, they're going to try to sell it. They're probably not going to be able to, just like you couldn't, which is why you gave it to them. So, think about that as it relates to that. But talking to the nonprofit's really, really important. Establishing charitable trust. This is the other side of it, right? This is where you're not giving them something specific. You're creating a trust that they are the beneficiary of. And we'll kind of talk about this a little bit more. But your types of charitable trusts are generally going to be like your private foundations, right? You at death or even during life, you put X dollars into the private foundation, $1 million, $5 million, whatever. And that foundation is managed by trustees. And those trustees just, invest the money or do something with the money in order to distribute to your beneficiaries. Private foundations have to give 5% of their fair market value away on an annual basis. So something to keep in mind. It's why real estate, artwork, things like that, a private foundation can take them, but they're not great candidates because unless their plan is to sell it right away, because they really need cash in order to make that distribution on an annual basis. Charitable remainder trusts or charitable deed trusts, these are structures that allow you to put money into a trust for the benefit of a charity, but you retain some interest in the income stream, generally speaking, from the asset. A really common one for a charitable remainder trust are highly appreciated securities. You bought Apple stock when it was $10 a share. Now it's $1,000 a share. If you sell it, you're going to generate, X dollars in capital gain, and you'll have, something, significantly less than if you donated that stock to a charitable remainder trust and then took income from the sale over a period of time. That actually counts as a charitable gift and is a common structure. We see that sometimes as well with like apartment buildings or pieces of real estate. Maybe you don't want to be a landlord anymore, but you sure do like the income coming in off the property. We contribute the property to a charitable remainder trust, sell it, and then you have an income stream from that during your life. And then at death, the rest of the money goes to the nonprofit. So that can be a really nice structure. Something obviously to talk through with your planner and your financial advisor and your attorney and everything, but really a kind of a neat concept. All right, next slide. Mm-hmm. Types of bequests. So again, specific dollar amount, very easy. $100 to X, Y, and Z, $500 to 1, 2, 3. You can also do those in percentages. You can do those with, a percentage of the estate, percentage of an account. Kind of the sky's the limit there. We always try to keep it simple so that it's not subject to problems later. But chances are, if there's a reason why you want something done a certain way, it can be done that way. Personal property. So again, bequests of items like artwork or jewelry. one of the best things that you can do, particularly if you have multiple beneficiaries. So think about your situation where you have more than one child or something, and you have kids that are going to want property from the house, like artwork or jewelry or certain mementos. Talk to your planner about coming up with the strategy for how to distribute those things. A lot of times, the default in most documents is that the parties shall basically work together to take items from the house, right? Or take the personal property that they want. And it's kind of left up to the administrator or the executor. That puts them in a tough spot sometimes, particularly because they also are probably one of the people that is going to take from the estate. And that can either be problematic because maybe they're being greedy, or it can be problematic because maybe they're letting everybody else take all the good stuff and they really want some things, but they don't feel like they should say something. The best kind of way that I've seen this done, and we talk about this, is really creating a structure for people to pick in a particular order. And there's sky's the limit on what you select, right? I've had clients create, basically put a number somewhere in the documents, and people have to pick, the number between 1 and 100, and whoever's closest. That's kind of a fun little thing. You could do it based on age. You could do it, based on whoever's birthday is closest to the date of death. I mean, we've done all sorts of stuff that people sort of like. But regardless, what you're trying to do is create something where you can go in an order that people are taking assets until there's nothing left that anybody wants. And then after that, the rest of it goes and gets sold either at an estate sale or it's donated. And, you kind of go on from there. But give some thought to that, particularly if there's more than one person that might want some of your stuff. Real estate or other tangible assets, right? How are we going to get those assets over to them? The law changed dramatically in 2019 related to the transfer of real property from parent to child. It used to be pretty nice set of rules in California. Most of you are probably benefiting from property taxes that are protected under Prop 13, meaning they can only go up a maximum of approximately 3% annually, right? Well, that changes if there is a change in ownership or control, right? If you sell the property, if you gift the property away, things like that, that person that receives it may or may not get that same property tax. And under the old rules, if you gave it to your kids, pretty high likelihood they were going to keep that same property tax. Under the new rules, Prop 19, much more challenging to keep that property tax. It had to have been the property that's gifted to them had to be your primary residence, and it has to become their primary residence within 1 year of your date of death. And so it does not work for things like rental property, right? It used to be that it worked for rental property up to $1 million of assessed value. Today, it doesn't work at all for rental property, only works for the primary residence. Wow. The other thing that it does is as to the primary residence in the past, it used to be unlimited, right? You could have bought the house for $500 and it could be worth $500 million, and you give it to your kids and the property tax remains the same. Under the new rules, which aren't that new anymore, but they're new to a lot of people. Under the new rules, you only get $1 million, assuming you meet all the other requirements, you only get $1 million worth of estate or worth of property tax protection. So if the difference in value, let's use this as an example. You bought your house in Pasadena for $75,000 and it's now worth $2 million, right? And throughout the years, you've had that little increase every year. So you're really, even though you bought it for $75,000 and it's worth $2 million, you're paying tax on $150,000 worth of assessed value. Well, that difference between $150,000 and $2 million, its fair market value, is going to be the reassessment, and then they're going to give your child, assuming he meets all the other requirements, $1 million credit against it. So it is going to dramatically, in that scenario, increase your property tax. So something to be aware of. It oftentimes makes the retaining of property more challenging for the kids because they may not be able to afford it, or if they're going to rent it out, they don't get any protection. They really have to make it their own home. It becomes even more complicated if there is more than one beneficiary. So that's something, if you have that scenario, you really need to run it by your attorney or somebody who understands Prop 19. Most, I mean, a fair number of attorneys do at this point, but I still am surprised by the number of folks that get this wrong that are doing this on a regular basis. So definitely something to ask about. And then your residual bequests. After you've given everything else away, you've given your laundry list of assets away, you've given your dollars to AbilityFirst and other nonprofits, there's going to be something left, right? Unless you specifically gifted every single thing that you own, which is not practical. There's going to be a residue. Who gets the residue? Who's going to get everything once everything else is gifted away? That's oftentimes your kids, or a residue beneficiary. Could be an estate or could be a nonprofit. Sometimes that's a nice way to gift, right? You give your kids or whomever everything that you want them to have. And you say, okay, if there's anything over and above that, AbilityFirst can have it, Huntington can have it, whatever can have it, kind of thing. That's a residue gift. All right, next slide, please. All right, so incorporating philanthropy into your plan. We've talked about this, and I want to leave time for questions. Identifying charitable clauses that align with your values, right? I don't hate, but it always makes me sad when I see when we're administering plans in particular, not plans that we've drafted, but somebody has passed away, and there's nonprofits listed in there that are national nonprofits that are not connected to this person's life. And they were recommended by the CPA, or they watched a late night commercial, or something happened and this nonprofit just like made its way into the plan. If you're going to list a nonprofit, my advice is find one that actually is doing something that you care about, right? Chances are, if you're on this webinar, AbilityFirst is one that you care about, right? They've either done something for you or your family, or you appreciate what they're doing. That kind of gift goes a lot farther in a nonprofit like AbilityFirst, that is a local type of nonprofit benefiting a local community, than just another drop in the bucket to Goodwill or the Salvation Army at a national level. If you are associated with Goodwill and the Salvation Army, chances are you're not going to Washington, D.C. and dealing with them in their corporate offices. You're doing something local with them. Find what the local version of that is, and that's kind of where we get involved, and direct your gift there, right? Don't rely on national to share it down to the local level, particularly because they don't ask or care how you were involved at the local side, right? You think, well, they're going to see that I volunteered every Sunday at the Salvation Army on Main Street. No, they're not. They're going to bother me every week about when they're going to get their check, which is what happens. I'm not picking on them, but they all do this. When are you going to distribute the money in the Smith estate? When are you going to distribute the money? They don't know or care where you were locally involved at the national level. The local nonprofits, they are always trying to figure out a way to honor you as a gift giver, things like that. So talk to your planner about it, make it a lasting legacy from that perspective. We talked about charitable remainder trusts, right? These provide an income stream to you during your life, significant tax benefits, potential, significant income tax deductions and capital gain avoidance, but they have to be structured right. So definitely talk to your attorney and your CPA about that. Spend a second on charitable lead trusts. They work very similarly to a charitable remainder trust. A charitable remainder trust says, okay, I'm going to give this asset to the trust. I'm going to take income during my life, and then when I die, the charity gets whatever's left. Charitable lead trust is the same thing, but in reverse. You're going to give something to the nonprofit. The nonprofit is going to get the income stream during your life. And then when you pass away, the asset goes to your heirs. By and large, the charitable remainder trust is the more popular planning technique of the two, but both have their place. And sometimes, particularly where I see clients use the charitable lead trust, is they don't need the income during their life, and the income is coming from something that they don't want to give away to the nonprofit. So think about like some type of piece of legacy property that's been in the family forever, or just something that you want to hold on to long term. Charitable lead trust can be a great way to do that. Next slide. I think that might be okay, perfect. Q&A slide. So type, if you haven't done it already, I don't see any, but if you haven't done it already, either type them in there, or I probably can raise your hand and ask your question directly. We can try to get to as many as we can here. Lana, do you want to take the reins and handle that process?
Absolutely. I also want to remind everyone that you can go ahead and reach out to us. This is the contact information for both Lagerlof and AbilityFirst. You see the email address, also the phone number to call to schedule a consultation, or if you have any questions, feel free to reach out to us. You can also visit our website for Lagerlof and AbilityFirst. The websites are written here. And we also have some information about our offices and where we're located. Lagerlof offices are in Pasadena, El Segundo, and Encino. And AbilityFirst has offices in Pasadena, Claremont, Crestline, East LA, Long Beach, and Inglewood. With that said, does anyone have any questions?
Yeah, this is Bill Patzert. I have a question. Can you hear me?
Yes, we can.
Yeah, now there's a certain level of complexity here, but can you give us a ballpark figure on what the cost of setting up a trust with all the details involved?
Sure. Yeah, it's a good question. The cost will range. Obviously, and you nailed it based on complexity, right? So generally speaking, if we're talking about a husband and wife with one piece of property and investment accounts and things like that, you should expect the $5,000 to $7,000 range for not just the trust, but the will, the powers of attorney, the healthcare directives, the deed transferring the property into the trust, things like that. That's a general ballpark. Different types of trust, more advanced planning will be more obviously and separate from that. But even if you're doing advanced planning, you still need kind of that foundation planning. Again, you're paying a comparable will, right? Might be $1,500, but $1 million estate, which is easy to hit these days, being probated in California is probably going to cost about $40,000. A comparable estate administration for an estate like that, $1 million, a piece of property, maybe $5,000 to $6,000 after the fact. So it's significantly less long term, but it is a little bit more of an investment upfront. Good question.
So how would you make an appointment and come in and with all your details and then
Yep.
you'd guide us through it?
Yeah, the way that we would do it, if you reach out either using that info at Lagerlof, or I can put my email directly in the chat here. I'll do that right now. We would probably set either an in-person, if that's your preference, or a call, kind of a Zoom like this. We would say, here's a questionnaire, fill out a little bit of information. It helps guide us as to kind of the estate size, but a lot of it's going to be just going through over the phone with you, asking you questions about what's important, what are your assets like. I work out of our Pasadena office. For those of you that are here, it's easy for us to meet in person if that's what you want. I often go though to our El Segundo and Encino offices if you're there as well. It's really just a conversation. If you have sort of a financial statement, doesn't have to be anything pretty, but kind of a basic idea of what you own, what liabilities you might have, that goes a long way. That's super helpful.
Thank you.
Of course.
Thank you for your
Great question.
Will. We are at time, and I want to be respectful of everybody's time. Josh, should we take any questions via email?
Sure. Yeah, if there are questions via email, I put my email in the chat. Feel free to reach out. If it's to talk, schedule an appointment, great. If it's just a simple question, great. If you've got an old plan, and many people do, and you want somebody to take a look at it, happy to do that, right? Chances are if it's under 5 years old and everything else is kind of in your life has stayed the same and the people are nominated in there, I'm going to tell you, don't make any changes. Once you get past that 5-year mark, things start to change in your life that might necessitate a change. And that doesn't mean we throw it away. It just means that we modify it, usually with a restated trust or an amended trust, and just kind of get it up to current standards.
Great, thank you. Well, this has been very helpful and informative, Josh. We've certainly learned a lot. Thank you, everyone, for joining us. And Josh, thank you again for your time and your
Of
expertise.
course.
I want to
Happy to
remind
do it.
everyone that we have another webinar covering IRA charitable rollover retirement assets and donor advised funds on Wednesday, March 25th at 4 p.m. If you haven't RSVP'd yet for our second webinar, we hope to see you there. Thank you all again and enjoy the rest of your day.
Thanks, everybody.
Thank you.
Bye-bye.
Good day.